The broadcast is now starting. All attendees are in listen-only mode.
Oh. Hi everyone, welcome to Protect Your Brand On and Offline, our new webinar by GoToMeeting, our last webinar for the Digital Ready program, with our guest presenter Jamie White from Pod Legal. I'm Jane, I'll be your digital coach this morning. Can everyone just raise your hands please if you can hear me okay? Just click the little hand icon on your control panel. Yep, great. Okay, that's good. Okay. So, in case we're not familiar with our webinar process, you're all automatically muted so that your background noise doesn't kind of interfere with everyone else. But please do feel free to ask questions if you have any questions for Jamie along the way or anything that you'd like to know regarding your particular situation. Just type it in the question panel and I will pick it up while Jamie's presenting and we will answer it as we go. If by chance we don't get to you during the webinar, we'll certainly answer it at the end. If you can stay on the line, if you can't, then we'll email you later. So do feel free to ask questions at any time if you have any that relate to you. And you might just want to grab a pen and paper if you haven't got one already, because there's always a lot of very useful information in Jamie's webinars, and you might just want to jot down a few notes. So without further ado, I will just hand over control of the screen and the presentation to Jamie. So just bear with us while we sort out the technology for a minute. There we go. And in a moment, you should be able to see Jamie's screen. Yep, looking good. Jamie, take it away.
Great. Thank you, Jane, and good morning to all our participants this morning. Just a tiny bit on me to start with, just so you know who is presenting here. I'm a registered trademarks attorney and lawyer with Pod Legal. I'm co-owner. Our firm specialises in intellectual property, which comprises trademarks, copyrights, that type of thing, and also technology and social media laws. So the reason I raise that is to let you know that I'm well experienced in trademark matters. Okay, as Jane said, our presentation this morning is titled How to Protect Your Brand On and Offline. What we're going to be covering today is firstly trademark, so we need to get that clear so we're all on the same page. We're going to discuss how to choose a trademark, how to choose a good one, of course. We're going to discuss the benefits of registering your trademarks and what the investment would be to register your trademarks. That's a very important issue to cover off. The ROI, the return of investment, what do you get for investing in your trademarks? We'll talk about the cost of not investing. What if you just put it aside in the too hard basket or not for now basket? What could be the consequences of that? I'll talk you through the application process, the various stages. We'll talk about what you can do with your trademarks once they are registered. We'll give you some trademark tips, some valuable things to take away. And of course, we'll have a nice little summary to tie everything in also. Jane, just before I go on, there is a little bit of background noise, a little bit of static beeping perhaps. Can you hear it?
Yeah, I'll just mute myself. Is that better?
It appears to be. Don't go too far away though. Jane, just so you know, I can't hear you now, but of course, I would imagine you'll jump in if need be. So I'll just carry on.
Yeah, I'll just keep myself muted and I'll jump in if there's a question or I need to make a comment. So I'll mute myself now.
Right.
Okay.
Thank you. Moving right along. So just a little bit of background before we start. Firstly, I want to expel a myth, and that is that, you know, I have a company name, business name, or domain name registered, therefore I own my brand. That is exactly a myth. Okay, you don't own your brand if you have any of those or all of those things. They're identifiers only. They identify a domain name or a business name or company name only. So legal ownership of a brand or a trademark, we'll use those terms interchangeably, brand and trademark, can only be achieved through trademark registration. Okay. The other thing I want to give to you in terms of context is the fact that trademark disputes occur every day. the media only reports on the big ones. So trust me when I say that any given day there's at least one trademark dispute coming across our desks here at Pod Legal. They're very, very frequent, unfortunately. Also, I wanted to reinforce a point that the consequence of not owning your brand can be fatal. And I know that sounds very dramatic and all doom and gloom, but unfortunately it can be doom and gloom in some situations, because quite often the consequence of not owning your brand might be a third party compelling you to rebrand and or pay money to them by way of damages for using a brand that might be very similar to theirs when you don't in fact own that brand. So that's just a little bit of background. So let's get into the juicy stuff now. What is a trademark? Well, we kind of all know what they are, but I guess more technically, a trademark can be a sign, word, logo, a scent, a shape. If you can imagine the triangular shape of a Toblerone chocolate, that is a trademark shape in relation to chocolate. So you won't see someone else bring out a chocolate in a triangular shape. They will have the exclusivity over that shape in relation to chocolate. Trademark may be a colour. It could be a sound. So the ding of the microwave in the McCain ads, that, believe it or not, is a registered trademark, a registered sound mark, in fact. It could be a numeral, or it could be an aspect of packaging. And again, Toblerone might be a good example of that, with the triangular packaging for chocolate. So when we think of trademarks, we think of Nike, Adidas, Hungry Jack's, McDonald's, those types of brands. It's important to understand what a trademark cannot be. And I should clarify that what a registered trademark cannot be. It cannot be a descriptive term, so it can't purely describe the services that you're offering or the goods that you're offering under a trademark. It can't be a trademark that indicates the quality, kind, intended use or value of the goods or services offered under the trademark. So, for example, you couldn't have a trademark registered that gives you exclusivity over the term $2 donuts. That's indicating the value of the goods, $2. And there's no way that you will get a monopoly for that through trademark registration. It cannot be a common surname. So my surname is White. I would very much struggle to get exclusive rights over that name in relation to any types of goods or services. It can't be a geographical location, so it couldn't be Mornington Peninsula honey, for example. You would not get a registered trademark for that because other traders on the Mornington Peninsula who produce honey should also be able to use that term. So a monopoly won't be given, once again, through trademark registration. A trademark also cannot contain scandalous matter. And an example of that is, I guess, as marketing strategies and brand names become a little more edgy in order to try and stand out in the marketplace, they're using edgier language, and therefore applications are going in for trademarks that are a little more edgy, might contain swear words, that type of thing, or at least connotations. So you can't register those. We've seen one or two examples in recent years of trademarks that contain scandalous matter, but I won't go into those right now. It's possibly not the forum for it. Might have to wait till we get the R18 version of this webinar released. Okay, so choosing a trademark, and this is something that all business owners are faced with at one point or another, whether it's at the start of a business life or along the way as you name products or services, or if you decide to rebrand, you'll be forced with the proposition, or faced rather with the proposition of choosing a trademark or brand name. So what makes a good one? What makes a good trademark? Something that is distinctive, in my view, something that's memorable, short, punchy, something that's easy to spell. A couple of real-life examples might be Google, Nike, and Adidas, perhaps, all quite distinctive. So the question begs, descriptive or distinctive? I think I kind of indicated what my view is, that trademarks should be distinctive, but there are some benefits for descriptive trademarks as well, and quite often people come to us looking to register their trademark that they've already coined or paid someone else to coin, and they've invested money into the early stages of branding, and that might just be stationery and logo and website, or it might be sign writing, or it could be a number of things. But the disadvantage of a descriptive trademark is that you will not get a monopoly over it, because recall on our previous slide that a trademark, a registered trademark cannot be a descriptive term, because you should not be able to get a monopoly over it. And remember, trademarks are all about obtaining a monopoly, exclusivity. So one of the benefits that new clients, or any client for that matter, often spruik to us in arriving at a descriptive trademark is that it's fantastic for SEO, search engine optimization. It's great for people searching you on the internet. It's great to have a domain name that's descriptive of the goods or services that you offer. And that may well be, and that may well be today, but the disadvantages are, like I said, you'll never get that monopoly. Google could change its algorithms radically at some point, so you're no longer rewarded for those descriptive terms, particularly in a domain name. And the real downside in our view is that it means your competitors can use very, very similar descriptive terms to describe their products or services. So it means that you're going to really be sharing that brand in the marketplace. And worse still, one of your competitors with a similar name might offer really, really substandard services, and people might mistake those for yours, which has a potential of damaging your brand. So I always cringe just that little bit when someone says, oh, my web guys or my SEO guys or whoever, my business coach, whoever it may be, suggested that I have a descriptive domain name or brand. In our view, that often leads to trouble. I guess the benefits of a distinctive trademark is that you will stand out in the marketplace. It allows you to carve out that niche or competitive advantage in relation to your goods or services. It means you can own your registered trademark, and we'll talk about some of the benefits of that soon. So really, really important that you get good advice when coining that new brand or product name. If you don't get that good advice, you want to make sure, in my view, that it is a distinctive name, one that will stand out, one that will distinguish your goods and services from those of a competitor. Okay, so any questions on that so far, Jane? Anyone like to challenge me, perhaps? I'm always open to challenge on this issue or any other issue for that matter, but any questions?
I've just got one. Our participants don't, but I do. Everyone, do feel free to jump in if anything occurs to you. But you were talking about trademarks in the context of SEO, Jamie. And my question, I'm not sure of the law on this, is can a direct competitor nominate your keyword if it's trademarked for a SEM campaign? So, for example, in the case of airlines, Jetstar might buy Virgin or Virgin Australia. Is that legal now, or?
That's a really good question, and some time ago, maybe 12 months or so ago, I could have answered with you know, that is a very, very questionable type of conduct. It will quite possibly lead to trademark infringement, maybe misleading and deceptive conduct, perhaps passing off, for example. Things have changed a little bit in terms of the law. The legal position is far less clear now. I won't go into it too much because it is quite complex, but basically if you use a competitor's trademark as a search term in your Google AdWords campaign and it causes their brand name to show in the ad, then you are likely to be in breach of the law. But please don't, anyone here listening today, take this as legal advice to them. It is a complex issue and it's a case-by-case basis, but the law is changing in favour of the marketers using competitor search terms or trademarks rather as paid search terms. So just be very, very careful around that, but a great and topical question. Thanks, Jane.
Okay, thanks, Jamie. I'll let you get on.
Great. Moving right along. So what are the benefits of trademark registration? Well, firstly, it gives you a 10-year registration period. So when you apply to register your trademark and it's all done and dusted and registered, you have a 10-year registration period that provides you with exclusivity in relation to your trademark for the goods or services that you register under it. Those trademark periods, 10-year periods, are renewable. So you could have it for 100 years, but you will be required to renew and pay a renewal fee every 10 years. The renewal fee is not too expensive, and we'll get into some costings shortly just to give you all an idea. Another benefit of trademark registration is the fact that you get to use the R symbol, the R in the circle symbol. That denotes a registered trademark, and if you accompany it alongside your registered trademarks and brand names, that will serve as a big deterrent to any potential infringers. That says, hey, I've got a registered trademark, back off because I will enforce my rights and I most likely will win because it is registered. You, as the owner of a registered trademark, have the ability to enforce your trademark rights under the Trademarks Act. If you have not got a registered trademark, you have to rely on other sources of law. The Trademarks Act will not be there for you. The benefit of the Trademarks Act and enforcing your rights under it is that you get the smackdown pretty quickly and efficiently, which brings me to my next point, that disputes or enforcement of your rights are usually resolved quickly and favourably if you've got the registered trademark. That's the ace. That's the big kahuna that you want. What else can you do with your, or what other benefits are associated with registering your trademarks? Well, you can license or sell your registered trademark. You can do that with unregistered trademarks as well, but it's kind of, you know, that's far less stable. A person buying a trademark will usually want to know that it is registered, and they'll do their due diligence around that, which is really only a 5-minute job if you know what you're doing, so it's easy for due diligence to be carried out. When we're talking about licensing your brand, we're talking about retaining ownership of your brand or trademark, but allowing someone else to use it. And of course, that's usually for a fee. Not always, but usually. A registered trademark you can transfer. It's a form of personal property. You can transfer it to another person for a fee. So you can sell it. In IP world, that's called assigning it. Another benefit of registering your trademark is that it will strengthen the value of your IP portfolio, which might consist of trademarks, both registered and unregistered. Of course, the registered ones are more valuable. Might consist of domain names and things like that as well. 1-800 phone numbers, social media handles, things like that. One of the final benefits that or the final benefit that I'd like to raise that is associated with registering your trademark is that if you are selling branded goods, so selling goods with your trademark on them, registered trademark that is, you could lodge a notice with the Australian Customs Service to keep an eye out for the importation of infringing goods. So goods that maybe bear a similar trademark and those goods are similar to yours. It might also relate to counterfeit products. So that's a common strategy for trademark owners to use to make sure that there's not cheap knockoffs coming into Australia with a similar brand name. Okay, is there any further questions, Jane?
Not at this stage, but I've got another one. Should you trademark misspellings or similar names? You might be coming to this later, but in the process of trademarking, should it only be your business name, or should you kind of trademark things that are similar?
Yeah, that's a great question. What you're referring to, or what you're asking rather, is you know, is there use in taking up a defensive strategy by registering misspellings of a domain name or variation, sorry, of a trademark or variations of one? The answer to that is no, because in relation to trademarks, it's a use it or lose it type situation. So to maintain a registered trademark, you must continue to use it. I would suggest that you probably would not use misspellings of a trademark. You would only actually use the actual trademark itself. However, I want you to contrast that position with, or change that question to, should you undertake a defensive strategy in relation to domain names? Okay, my answer would be yes. It's very important. In fact, I recommend you can all jot this down. register variations of your domain names, your key domain names, to ensure that a competitor doesn't beat you to it. And I think for most of us who read the news or listen to the news, actually it was hard to escape, whether it be on the internet or TV or radio. A couple of weeks ago, there was a big dispute, I guess. I don't like using the word war, but that's the term that's been used to describe this, between a couple of bloggers, and that's exactly what's happened. One blogger was carrying on her very successful blogging business on one domain name. One of her competitors came in with a very, very similar domain name. In fact, it was so similar, all she did was put the word "the" in front of the domain name, and then directed traffic from that domain name through to her actual website, which was a totally different domain name, but again for similar services. And look, there was no winner or loser in that, I don't think. Some may argue that the one with the sneaky tactic, using a competitor's very similar domain name, they might have come off second best due to a lot of uproar online, a lot of chatter, a lot of criticism. So there was some damage to the brand there. But unfortunately, the owner of the actual trademark and website didn't have a registered trademark. So we talked earlier about how you can resolve disputes very swiftly and in your favour if you had a registered trademark. This person didn't, which made it a whole lot more difficult to handle. So I guess to get back to the question, Jane, always very, very important to register, 4, 5, 6, 7, 8 variations of a domain name. So if you have the .com.au, try and get the .com. If that's not available, get the .net, the .net.au, the .biz, the .info, for example. And these days, domain names are very cheap. So really, for well less than $100, you can cover off some potential grief down the track.
Okay.
How does that sound, Jane?
That's great. Thanks, Jamie. That answers my question. Okay.
Great. So moving on to another important part of today's webinar. A lot of people want to know how much a trademark will cost, and that's a really important question because a lot of people think that it's out of reach. And what I can say is that they start at around $1,500 for the 10-year registration. And the reason I'm vague on that is because that's for a single class application. So if all you do is sell milk, you will only require your trademark to be filed in one class. So the cost would be around $1,500. If, however, you are a shop and you sell bikes and you service them, that's two classes, selling and servicing, two classes, and the cost would go up to around $2,000. The government fees go up. Professional fees might go up a little bit as well, but so it does scale. I wouldn't say it's strictly $500 per class extra, but it's a rough guide, maybe $600 or $700 extra usually. So it depends on the cost of your trademark registration. Will depend on the scope, how broad the scope is of the goods or services that you're offering. Okay. I guess to break that down, 10-year registration, to put it in perspective, it's $150 a year. If you look at it that way, not so expensive. The costs are spread, which is a good news thing. Of that $1,500 in this example, roughly $800 or $900 of that would be payable upon the trademark application being filed, and the balance would be some 7 or so months later when your trademark is ready for registration. We'll talk about the process shortly. Something that's optional but recommended is trademark monitoring services. So whether you have a registered trademark or not, this is a good strategy that more and more brands are employing, and that is there's software out there, usually through your IP professionals, that can monitor trademark applications being filed and use of your key brands on the internet and elsewhere. The benefit of this is that you can detect a competitor's misuse of a trademark or someone applying for a trademark that's too close to yours. Detect it early and deal with it swiftly then. Far easier to enforce your rights and deal with it early on than down the track when someone believes they've spent a lot of money on developing and promoting the brand and developing a reputation As indicated on the slide, the trademark monitoring, which again is optional, you're around $60 per month, and that's a stop-start thing. Whenever you want to stop, you can. Whenever you want to take it up, you can. But it's good. It's a good service. Some of the searches will allow you to monitor your competitors and see what brands they're seeking to register. This is particularly a useful strategy for big brands to determine what products their competitors might be bringing out shortly. Apple and the likes will definitely use these strategies. Okay, so I guess whenever we make an investment, we want to know what the return on investment might be. Well, firstly, you get that 10-year registration, which is renewable. We talked about that earlier. We've also talked about the exclusive right to use your trademark. You also have the exclusive right to control the use of your trademark. So we talked about licensing briefly earlier. You can allow someone to use your registered trademark on your terms. So it might be for a period of 12 months, it might be in Queensland only, it might be non-exclusive use, meaning that someone could have the New South Wales territory, for example, and of course, importantly, it'll work out what the fees are or how they are to be calculated. So there's different ways that you can nominate a fee, whether it be a once-off fee, an annual fee, it could be a percentage of sale fee, it could be a per-user fee, if they have some sort of subscription model business that they're going to use a trademark for. So it basically means that you have something that you can dictate terms around and commercialize. Also, a registered trademark is a very valuable commercial asset on your balance sheet, and banks will recognize this. We know that for a fact. Unregistered trademarks may have some value, but it's very difficult to establish because you would need to show that you have some sort of reputation and the extent of the reputation in relation to that trademark. So definitely a registered trademark which is very, very strong is going to attract the greatest value on your balance sheet. So that's another way to not justify taking out a registered trademark, but it's another incentive to do so, that's for sure. Is there any questions around that, Jane?
Not at this stage. I don't have any. Does anyone have any questions they'd like to jump in with? Please feel free. If you want to put up your hand, I can chat to you privately. If you're a bit uncomfortable about typing, that's also fine. Nope. Okay. No, not Sam. You seem to be answering everyone's questions as you go.
Oh, great, great. Okay, moving right along to the cost of not investing. I probably should have asked for questions after this one. It ties in with the last. Well, I guess the obvious cost associated with not investing, or the risk, I guess we could say, is that you will not legally own your brand. Okay, so that means it's going to be vulnerable. It means that you won't have the Trademarks Act to enforce your rights. Remember, we talked about how effective that is. You will have other rights under other areas of law, for example, misleading and deceptive conduct, if someone uses a similar brand in relation to similar goods and services. But I often compare that to a pillow fight in comparison to a dispute where one party has a registered trademark. We've all had a pillow fight. They can go on forever. No one really, there's no outcome. No one gets hurt. And when legal matters take a lot of time, they of course cost more money as well. So another reason to have your trademark registered, but that's certainly a risk of not having it registered. Okay, the third point we just discussed as well, and yeah, I'll just reinforce the last point, that someone else may get in and register a deceptively similar trademark. And of course, you have the right to jump up and down, but to have it removed from the trademarks register or challenge it during the appropriate opposition period throughout through the trademark process, it's costly, it's time consuming, of course, stressful. So again, that is a risk of not investing in a trademark registration. Okay, on the basis that there is likely not to be any questions in relation to that single slide, I will move on, and if you do have one, we'll address that later on. Okay, so the trademark application process. It's not a matter of just jumping on IP Australia and filing an application yourself. There's some stuff that you need to consider. Firstly, before you decide on a brand name or a trademark or product name, you need to conduct all the relevant searches. And the reason for this is to make sure that you're not going to be inadvertently infringing upon someone else's trademark rights, someone that's been around for a while. And it's not just a matter of searching the trademarks register, because that person using a brand that might be similar to the one you've just coined may not have a registered trademark, but they will have those other rights as we described earlier. So the last thing you want to do is come up with this great brand name and start spending money on the development of logo and branding material, marketing material, website, sign writing, stationery, stuff like that. And then 10 minutes into the life of your business, you get a cease and desist letter to stop using that brand name and rebrand. And usually they give you about 7 days to do that. So for that reason, conduct all the relevant searches. You're best going to an experienced trademarks attorney to carry out those searches, because they are comprehensive and they need to be extremely thorough. Okay, so once you've got the all clear on your new brand name, you need to have the application filed. Now, I know that some people file their own. That's risky business. I often compare that to me fixing someone's car. I don't really know what I'm doing, but I can probably, maybe get the wheel, spare wheel on, or put the oil in it, but who knows if I've done it right and when it's going to come crashing down. Similar thing with filing your own trademark application. Quite often we're faced with a scenario where someone goes to enforce their rights, they file their own application, and they've actually filed in the wrong class. This is something that happened very, very recently, in recent weeks, in fact, to one of our clients, and it led to huge disappointment. They weren't able to enforce their rights against an infringing party, and furthermore, their application was absolutely useless, or in fact, their registration was useless because it was in the wrong class. It's not up to IP Australia to tell you that it's in the wrong class, so that's a trap for people at home. Something else. Go on, Jane.
Just a quick question there. Where you say, just going back to conducting all relevant searches, I presume that people can just do that online, do they? Or do they need to ring someone? Or if you're not...
Oh, look, you can carry out the searches yourself, but you only know what you see. As I said earlier, the searches are comprehensive and need to be extremely thorough. So I would always recommend that you go to an experienced trademark searcher to get that service. And again, we're always open and transparent about costs. So if someone wanted to come and get comprehensive searches and our opinion on the registrability and whether or not someone's trademark is going to be infringing third-party rights, our fixed cost is $495. And you will get that report. It will highlight any risk areas, any people that may have prior rights, and we'll tell you whether you should proceed with that brand name or not. Yeah, so it's kind of like your insurance policy, if you like.
Okay, so better to go with a professional when you're,
As always, better to go to a mechanic than the next door neighbour to fix the car,
Yep, sure.
if you know what I mean.
Yeah, for sure.
No, I mean that very respectfully. Okay. The application. You file the application, the Trademarks Office will allocate a date that it was filed, and that's the date that you'll be protected from. So if you're thinking about registering a trademark and you know that you're going to do it, get onto it, because that will establish a date that you're protected from. Okay, sometime later, usually 3 or 4 months later, the Trademarks Examiner will examine the application and the trademark subject to it. They'll make sure that it's not all those things or any of those things that we discussed earlier when we were talking about what a trademark cannot be. They'll make sure that it's not a descriptive one, doesn't contain scandalous matter, doesn't use those geographical locations or common surnames, all those things. But really importantly, they'll check the trademarks register extremely thoroughly and make sure that there's not a pre-existing trademark that they need to cite in relation to your trademark. So I guess to put that a little bit clearer is if there's a substantially identical or deceptively similar trademark already on the trademarks register, then the Trademarks Examiner will refuse your application. That's not fatal to your application. It can be overcome, but it's usually through legal argument or providing substantial evidence of use of your trademark, and that's usually over 2 to 3 years. Okay. If there's no obstacles, if the examiner says, yep, that's a distinct trademark, because the test is that it needs to be distinctive. Your trademark has to have the capability of distinguishing your goods or services offered under the trademark from those of other people providing or offering those goods or services. If there's no obstacles, the application will be accepted for registration. Soon after, it will enter into what we call an advertising or opposition period. That's where there's an official journal issued by the Trademarks Office, and it publishes all the accepted trademarks for a period of 2 months. And during that time, any other trader who might be concerned about the registration or acceptance of your trademark, they can jump in and file a notice of opposition, setting out grounds as to why it shouldn't be accepted for registration or proceed to registration. So they can challenge it. It's a 2-month period where they can challenge registration of your trademark, and it's usually done on the grounds that it's too similar to an existing trademark that the challenger usually owns on the trademark. So, you know, if we file, say, 100 applications, it might well be that 2 or 3 are opposed. So it's not a common thing. If you go to register a trademark knowing that there is someone already out there with a registered trademark or an unregistered trademark that they've applied to register it, then there's a good chance that it's going to be opposed if they're aware of it. And the thing is, they need to be aware of it. Not too many business owners spend their days searching the trademarks register. The savvy ones will have that monitoring product, and their lawyer will alert them. The lawyer will say, hey, someone's just tried to file an application for a brand name that's too similar to yours. What do you want to do about it? And then you can make that informed decision. If there's no opposition, then the trademark becomes registered upon payment of the registration fee. Remember of the $1,500 example earlier, we said roughly $800 or $900 is payable upon filing the application. Well, the balance needs to be paid once the opposition period has expired. Only then will your trademark become registered. Okay, are there any questions about the trademark application process, Jane?
No, not at this stage.
Great, I'll kick on and we'll have time at the end for a few more questions. Okay, is everyone awake, Jane?
Well, I think so.
They're all still with us?
They're all mesmerised by your expert.
Everyone still with us?
Yep. Yeah, they're still with us.
Thank you. I was searching for a compliment and it was received. Thanks, Jane. Moving on. Okay, your trademark's now registered. What can you do with it? What now? Well, like we've said, but I'll reinforce it again, you can use it exclusively in relation to your goods or services. It creates that niche. It allows you to build your reputation while keeping competitors at arm's length in terms of use of a brand similar to yours. You can, in turn, that provides you with a sustainable competitive advantage. Okay, you think about McDonald's, no one gets near them as far as burgers or drinks or cafes or toys or events or anything else goes. They have that competitive advantage, similar to the Coca-Cola brand, I would say. You can license it, receive license fees, as we talked about earlier, or royalties, which are usually in the form of a percentage of income or sales of a product that's using your brand. You can assign it. It's not an uncommon strategy for someone to build up a brand, register a nice logo, build up some sort of reputation, and then assign that, meaning transfer it to someone else for payment of a fee. When you license something, that means you keep ownership and you just allow someone to use it. Think about it as loaning your car to someone. When you assign it, you sell that car, or in this case, a trademark. It's a once-off payment. Ownership transfers. When you assign a trademark, it's quite often as part of a business sale, but it might just be that you have registered a trademark in relation to particular goods or services. You think it's a great brand. You might even own the corresponding domain name, and then you might look at selling it to someone who might be able to use those. That might be by way of a strategic sale. So you might have a particular business or industry in mind when you develop that brand or logo and look at selling it. We see that more and more often. Having a registered trademark, something that you can do with it is use it as a foundation for international trademark protection. So one of the filing strategies, if you're interested in registering your trademark in overseas countries, one of the filing strategies is through what we call a Madrid application. And that's a more efficient and cost-effective way of registering in multiple international countries. But to do that, you do need a strong Australian trademark. It doesn't have, excuse me, it doesn't have to be registered, but a lot of people will wait for it to be registered so they know that it's secure. Because the downside of some international trademarks, particularly those under that Madrid system, is that if your Australian trademark is, which forms the basis of that application, if it's vulnerable or challenged or ends up falling over for some reason, then so will your international ones. Very, very important to keep that in mind. And again, when you're considering your filing strategy, you want to consult an experienced trademarks attorney or IP lawyer. What else should you be prepared to do? Yeah, go on, Jane.
Quick question on that. If you go to a professional in Australia, will they also be able to handle your international trademark protection, or is there a different person to do that?
Yeah, no, your Australian lawyer will do it. I recommend that they're experienced in international trademarks because it is very, very complex. It's not something that you typically do yourself. You need to have an agent on the ground in many of those countries.
Mm-hmm.
But yeah, there's multiple ways of filing overseas, and depending on your circumstances and what your objectives are and what countries they are, as to which filing strategy is best for you. So I always recommend that you seek a professional who's experienced in this type of thing.
Yeah.
What else?
What about
Go on.
what about something like Chinese characters and things where obviously the logo will be different and the name might, like, in a different language or a different alphabet? Really,
that's yet another reason why you want to seek the services of an experienced trademarks professional. And in relation to China, someone that's protected or enforced trademarks in China, something that you need to consider is whether or not you'll need to do a translation of your trademark for particular countries. But also something that is really, really important and often overlooked is cultural sensitivities and the likes of any particular country. You need to make sure that your trademark's not going to be offensive due to local cultural customs. So, things often get lost in translation. We often see those spammy emails that show all the signs, in China in English, and they're ridiculous what they say, but they don't really realise how it translates. So, so it's again a trap. So you need to make sure that you get the right advice around that.
Okay, great, thanks.
Okay, I might just add to that. This isn't part of the slides, but if ever you're going to get advice, I know that people think lawyers are expensive, and many are, and I'm not suggesting we're the cheapest. We're not, but I always recommend that when you're dealing with a lawyer or any other professional service provider, get a firm cost up front, and preferably a fixed fee cost, so you can lock it in. There's no way, I keep going back to the mechanic and the cars, there's no way I drop my car off and say fix it without asking how much it is or getting them to call me if it's going to be over $300, for example. You need to get that transparency going. You need to know, have some certainty around how much it's going to cost. So always do that.
Okay, great.
Okay. Moving right along to a few trademark tips, and we're getting towards the end of the presentation. Use the TM symbol for all your unregistered trademarks, and I should have circled, underlined, and bolded unregistered there. So the TM symbol, all of you can use today in relation to your unregistered trademarks. Okay, so you don't have to take any steps to register your trademarks. You don't have to initiate the application process, but get the TM symbol on alongside your brand names, business name, product names, and the benefit of that, it doesn't strengthen your rights in any way, but it acts as a deterrent. It serves as a deterrent to any potential infringer. Recall that the R symbol, the R in the circle symbol, is for registered trademarks. Really important to make that distinction. TM, unregistered. are for registered. Big deterrence. Use a registered trademarks attorney who is also a lawyer, and you might be scratching your head going, what does that mean? It means that, believe it or not, a trademarks attorney or a person can become a trademarks attorney through the study of a course. Admittedly, it's a fairly comprehensive course, but they may not be a lawyer. They might come from some other background, so HR, for example. So it means a HR person can go and do a 12-month course on trademarks, a fairly intensive course, but then they come out as a trademarks attorney. The benefit of having someone that's also a lawyer is that they understand all legal aspects of trademarks law. So really, really important there. So don't be afraid. If you're going to entrust your brand, which is huge, in the hands of someone, make sure that you ask the questions around what qualifications do you have, what experience do you have. I'm going to be filing an overseas trademark. Can you show me that you've successfully done that? Ask the questions. Don't be shy. Lawyers don't like the questions too much, but a good one will answer them openly and honestly. And I guess my last tip is don't try this at home. Like I said earlier, it's pretty easy to file a trademark application, but it's only when you go to enforce it or it's challenged that you start to see how wobbly it is, or in some cases, worthless. Okay, so in summary, trademark disputes occur every day. It's only the big ones that we see in the media. Choose a distinctive trademark rather than a descriptive one. Enforce your rights efficiently and favourably through having a registered trademark. Registered trademarks are valuable commercial assets. Trademarking is, in my view, not expensive. Others may have an alternate view, but starting at $1,500 for 10 years. Commercialise your trademarks. Make money out of them. I'll use a term that many seem to be using these days, and that is productize them. You know, if you've got a brand name, turn it into money. Use that brand. Make it a distinctive one so people know it's you and not someone else. The risk of trademarking, or sorry, the risk of not trademarking can be fatal. We talked about rebrands and the likes. Use your trademarks or risk losing them, and that's a point I made very briefly earlier in response to one of Jane's early questions. You must use a trademark. You can't just have a defensive trademark, have it there to stop someone else, because it becomes vulnerable to challenge. If someone challenges you and by doing so puts in an official complaint with IP Australia, the Trademarks Office, if you cannot demonstrate use of that trademark for a period of 2 years, 2 continuous years, then it may be removed from the trademarks register. So keep using your trademark in the form that it is registered. If you go and, you know, change your branding even just a little bit, you need to consider whether or not you also need to file a new application, because you may not be protected for the new version of your branding. Okay, that's my summary completed. Thank you very much, everyone, for listening in. I almost said participating, but it's been a very quiet group of attendees, but perhaps now there might be a few questions, Jane.
Yeah, so now's the time, everyone. If you do have a question that you'd like to ask or something's occurred to you throughout and we've been talking too much for you to get a word in, please feel free to type your question in the question box or put up your hand and I'm happy to unmute you. I just had a really quick one. Jamie, you mentioned earlier about the monitoring service that you recommend people employ.
Yes.
If they choose not to do that for whatever reason, is there any other way they could, I mean, how do people normally find out about trademark infringements of their brands?
Yeah.
They just stumble
Yeah.
across them, or...
Quite often, unfortunately, it might be a customer that says, hey, I went to this website thinking it was you, but I don't think it is. So someone might bring it to their attention. It might be a friend. That's often the case. Hey, did you see this brand? It's similar to yours. Some savvy business owners will just set up a basic search tool like a Google alert where you can put your brand names in, and just about every morning, or it seems to be in our case anyway, we use that as part of our monitoring, but we also have comprehensive software in place. But so you can use Google alerts. I'm sure there's similar services out there, but that will just deliver to your desktop a link to anyone using a brand that might be similar to yours, or you might put your name in from a reputational point of view. Use that as a Google alert search term, and then that way you can monitor your reputation online as well. So that's one way, but it's certainly not the most comprehensive or reliable way. But
Mm.
a combination of tools might be a good first step.
Yep.
But again, for $59 a month, if you're concerned about someone using your brand, it's probably a small price to pay to get on top of an issue early.
Yeah, sure. Okay. So that was the only question I had. I don't think there's any questions from anyone here. So, yep, doesn't look like it. So then,
Jane, if someone would like a little further information about trademarks or further reading, or if they're considering proceeding with the trademark registration, there is a free ebook on our website. You don't have to sign up or anything. It's just sitting there in the Pod Legal Learning Center. It's just a 5 or 6 page ebook on trademarks, and it will answer a lot of the little questions that people might have and don't care to ask right now.
okay, great. There is a lot of really useful and interesting information in the Pod Legal Learning Centre, everyone, and not just on trademarks, but on many other things that you might need more information on or need to be across as a business owner. So feel free to check it out because it's really useful. Okay, well, thank you very much, Jamie, for your talk this morning. As always, very interesting and informative. So just remains for me to say thanks to everyone for attending as well. I hope that you've enjoyed our webinar series over the years. This is the last one, as I mentioned earlier. So thanks, everyone, and good luck with all your trademarking. And thanks to Jamie. See you later.
Thank you, Jane. Bye all.